case that will push me.
Yes.
So you mentioned only 3 contracts, and you said that every contract will use just that. We talked about manufacturing contract but then I've come across, I've heard of, I've read different contracts in fashion law. At least I've seen custom design agreements, release clauses, and all of that. Are you saying that those contracts are not necessary, or that they can find a way to fit into those 3 dimensions? Because you feel that those 3 are just what is necessary.
Yeah, that's not what it is. In general terms, every contract, all those custom design, they are all still in your manufacturer's agreement. I'll give you an example now. So with us, sometimes we make one-off samples before the client decides they're going to make 200 of a particular dress, 300 of a particular dress. Now, they might send us 7 designs. They might send us 7 designs and decide to just make 3. All those designs are custom designs. So whether it is 1 design they're sending us, 3 designs, 4 designs, the agreement still covers everything. The only thing where I said that manufacturer's agreement is very, very important is from a business perspective, for a business that you're outsourcing your production. If you're just making that one item, it would be a manufacturer's agreement, but it will not be called a manufacturer's agreement. But the same way you would couch everything in the manufacturer's agreement, it will be the same way you will need to protect that one item. Like I said, it's only a manufacturer's agreement because I'm the manufacturer and you're the client and you're selling it to me. If I was a loan designer now, it would be like a design agreement.
So my second question is our last speaker. So you talked about AI and you're saying that you feel that using AI is not copying other people's design, that it's just like passing down knowledge to other people and all of that. But then there have been cases, for instance, Shin is facing about 5 cases in the US where people are saying that they use their AI mechanism and information and all of that to check or to do trend forecast and all of that. And they failed on some other people's design that is already existing. And then those people have sued them. A lot of people sue Shin. So what would you say in that kind of instance? Because I don't see it as passing down knowledge. I feel that when it comes to that point, like in those cases, you're now at that point infringing on people's rights.
Okay, I didn't say that. I didn't say that AI is not using AI is not used in other people's work or works. What I say is that other individuals feel that way, right? Don't forget that this is legal gray area. Legal gray areas are areas that are still developing and will definitely develop. So sometimes the law doesn't even develop them. It's probably just business of convenience that eventually ends up developing them. Financial Times currently sued that OpenAI some years ago, last year or so, and they reached out a workable model where whenever their data is used, they get paid a particular amount. So OpenAI pays them, and everybody's fine. So another thing that you need to know is that most of all these legal solutions are probably tied to how does the next party feel that he has not lost. The reason why people are making noise about their data is because they feel that something has been stolen from them. You can give them something in return. They won't be mad again, right? So that's why I feel OpenAI is supposed to be doing. Okay, that's my own opinion. I think with that solves a lot of problems and we can move on from this. Because whether we like it or not, we need to move on. Technology has to move on. If you're going to be, somebody only say you stole his work, you're not getting anything from it. Once you start getting something from it, you'll be cheap again. You know what I'm saying?
Yes. Just to bring up clarity on what I said. I think the Shin issue is not even around what he said in terms of AI. So what Shin does is they use an AI software that combs activity. So if there's a lot of activity around this laser now, the AI pushes it into a funnel that now sends that to the factory. Why? They can see that like 600 people around the world have their mouse on this item. So they don't know, they're not intent on coming to steal your design. Do you get? That AI is just funneling activity itself. That's why they have a lot of disputes in terms of this person saying they stole my design, they stole my design, they stole my design. They are not even trying to steal design. It's an after product of the mechanism that they designed. So that's why you have that. It's not that they go and they say, oh, they use AI to create design. They're not creating design. They don't create anything. They just funnel that activity into the factory. The factory makes it, comes out. And like I said before, most of these brands, by the time they reach out to them, discuss speaking English, they would have finished selling what they want to sell, and everybody will rest.
Okay, basically my question goes to the Fashion Law Institute. First and foremost, I want to know if you take in law students during their long period break, like the 6 weeks course, 8 weeks course. I want to know if you do that, and I want to know how you run your master class for intending fashion lawyers. Then your upcoming book, is it the order or something else?
Okay, so we offer internships to people who want to discuss them basically. I think largely most of the groundwork that we've done, obviously law students are allowed to come in to join. We only have, I think since 2021 we had like volunteers across our conferences, a lot of events that we've had. There's also the fact that we have master classes, but this year, obviously, we decided to change it, right? So the master class will be before the conference, and that's coming up in July. So we ran a survey last year, and a lot of people come for the master class. The master class usually goes in June. It's a 2-day master class. And then the conference is in November. So we got a lot of messages for people who wanted to attend the entire activity. So we decided to put it on the same month. So an entire week, we have the master class, we have the conference holding, and that's in July. We also have opportunities for lawyers to provide pro bono services to fashion brands. So we have a fashion legal network where lawyers volunteer, but we have a lot of issues, IP issues, contract issues, policy issues. And there's one case I recently reached out to you. It's also under fashion education, for example. There's a lot of bullying in fashion schools. A lot of fashion schools operate without registration or regulatory oversight. We've seen cases where fashion schools go and pick up their parents for them saying that, oh, I think this fashion school. And I'm not learning anything. I've paid 7 million. I think the last one was 7 million, right? 7 million in school fees, and I'm not learning anything. And then they found out, obviously. So we've had cases or reports like that, people reaching out to us to say, oh, can you help? Last week, I think on Saturday, my phone was buzzing, and it was the same issue of they are raiding our hostels, like IP. So those are issues, right? So we have lawyers coming to help. We also have, recently we came up with this resolution where we get mediators to mediate these issues. So really and truly, we can't do it ourselves. Lawyers have to come. So that entire week, we also have a day for lawyers to volunteer, and then grants can come in to assess legal services. So those are the things. And then the book is on pre-order. It's going to be launched during the conference.
Let me add, that leads me to one career path that I didn't talk about. But before I go too deep, I also recognize the presence of my people from last week. So now, a lot of people go for mediation, right? They go for mediation training. Some of them go for arbitration training. I would suggest that while you're going for most of this training, there are some other practice areas that you can position yourself around, right? One of it is fashion. Now imagine, do you know how many people that are facing mediation, are trying to divorce and need mediation? So before you can see their problems, you should be getting close to 3 people in a week. If you're getting 3 people in a week and just speaking fluent English with your knowledge, and you're having like virtual calls and you're sending invoices, that's a career path that is pretty good that you can capitalize upon. So while you are learning this, while you are trying to read up on things, think of unique ways to solve those problems and think of how you can own that space as well.
Yeah, and I also think that lawyers already have these certificates. I know in law school, a lot of mediation organization comes to them to actually write exams. And they actually get certified as mediators and all these things, but are they really using that? That's why we decided to come up with the alternative in this area. So your hand you.
Oh, yes.
Okay, you first.
All right. So my question is to you. In the course of your session, you made mention of fashion law and the Local Content Act. And generally, we know that the Local Content Act largely dwells with the oil and gas sector. So could you broaden on the relationship between the Local Content Act and fashion law?
Obviously, they are giving, oil and gas companies are giving quotas, right? So if they are going to run in Nigeria, they have to sort of like patronize Nigerian businesses. They have to have like 80% of Nigerian brands providing them with different services, from shoes to garments, things like that. So for brands to qualify to be among the pool that those companies would pick out from, they obviously have to be certified. They have to go through some screenings, right? So that's where the connection is, because any garment manufacturer looking to get contracts from those people would definitely want to get certified, and that's where lawyers come in. Yeah. Sorry.
That's what I was saying as well. Like, quota is not a suggestion. It's compulsory. So we make uniforms for a few oil and gas companies, and you need even, they will ask you for everything. Your annual returns, TCC, tax clearance certificate. They will ask you for everything, even if it is just 1 million they are going to spend. They would ask you for everything. Now the thing is that most of them, they will spend way more than that. But then that's also an avenue, because like I said, a lot of fashion brands they actually don't, they are not organized. So it's actually a very, very big opportunity. And speaking of fashion law, sometimes it's good to see somebody that has done something, rather than just be hearing. My fashion deal sheets by the end of September from 2022 August will be close to 600 million naira. And that's not the value of the deals. It's money I've made. In 2022, I did almost about $6,000 in consultancy for Zara. I did for IB almost about $20-something thousand. So it's from there. Then I still used to do oil and gas practice, which is fairly where I made my money from. But there's money. Even as I don't do a lot of fashion law stuff, there's money. The ecosystem is so young. Forget all these fashion brands that are everywhere, scattered everywhere. People have not touched the surface. I'm not sure we have any garment factory in this country that has 800, 500 staff. Even we're scratching the surface. If you get 2-3 international clients, everything, you are doing better than some people in some tier 1 law firms. So don't feel like, oh, it's just fashion, it's not, it was a trend. I always tell people, see, people say, oh, you're qualified, you have all these degrees, you have all these things. And I always tell them, I'm a humble tailor now. What I tell people. Granted that, yes, I did make money from law practice. So don't feel like, oh, it's just fashion. There's a lot of money there. Look at the big brands, there's so much money there. So please, it's something that you should actually take serious.
Her question is next, please.
It's not a question, but just last year during the AMPCA award, this particular Ghanaian lady won the best dressed. So there was this drag on Instagram where the young lady who made the clothes came out to tell her that she should have attacked her, that she was the one who made the clothes, and there was the issue that I paid you, I'm not going to do that and all that. The question I would like to have, does that invalidate the fact that she was the creator of the sew the dress? On getting
Well, I think I mentioned before that we forget who a tailor and a designer really is and who has IP. The person who deserves crediting, right, or credit rights is the person who has intellectual property rights. In that particular case, the intellectual property right has already been created and completed before giving to the tailor. So Olivia, yes, isn't it Olivia, was actually a tailor in that case. She was the one who just tailored the work, but the work was already original and fixed in a tangible medium when Nana made it. You can see that she did the 3D design. She brought all of the fabric, everything. All Ezine did was basically construct the dress already. So obviously IP was already gone. She doesn't have any right, so to speak. You get, so that's the problem we have with Nigerian.
I know.
I know you say that, but for me, I believe that there is a problem with nomenclature, right? Everybody who is a designer, sometimes you're not playing the role of designer, you're not coming up with a creative concept. You are the laborer basically in that particular case.
Question is based on what the last speakers.
Okay.
There are some digital fashion that some people don't wear. But this situation now, you brought her the picture and she created it.
They don't have the picture
of what they
process,
wanted.
the fabric, the materials, everything she was on. The only thing she did was make the inner dress, and that one was not going to. That's the inner. That's when you make Iro and Buba, and then somebody makes the inner cloth, and then you wear the main dress. So the main dress itself was already done and constructed somewhere else, according to the. She only just made the inner, so that she's not exactly naked. So will you call what she made original? And
so she's right, yeah. But then generally, I don't think it will apply in this case. But then in some cases, the technique of production can play into it. If the technique she's used to bring that garment to life, regardless of whether everything has been coupled elsewhere, is her own original technique, her own use of technology that is unique to her, she can have a say. But then if you just carried your industrial machine and it's not like you'll be paid for that service.
We have an alternative case like that too, right? It was on Twitter. The crochet girl made a particular dress, but she was commissioned to make it by someone else. The person brought, let's say, the illustration to say this is it. But when she made it, she said no, there was a different technique needed. They didn't know the kind of stitches they would use to produce that dress. That's quite different from what, you know.
Yeah, those ones.
Why I have is because the photographer, if I'm the one, and the person is taking my actual picture, is the author of the picture, irrespective of where I'm the one. That's why I asked that since she's the one that brought the garment to life, there should be some kind of compensation.
Well, that was so
It's
easy.
kind of
And then just like what I think the second and the last speaker said, your employee contracts.
Yes.
Whoever you are employing to do something for you, you can have the IP clause that whatever you've done is mine. So
No,
yes.
I have an idea.
she's no, it's still what he said. We've not tested the law.
Yeah,
We've
exactly.
not tested it. What you're actually saying now, the truth is that everything here is just opinion. She can be right, I can be right. But then if it's not been tested, everything is just conjecture. It's when we go there and we argue it, we can now see, okay, this makes sense, this doesn't make sense. But who wants to go and start arguing on this one in courts? These are the issues.
Okay, he had the call first.
So I just just wanted to ask, are there like other professional courses that somebody can take in fashion law that gives you certification so that maybe you can make yourself visible to clients that, okay, yes, I have?
Yeah, we offer that, right? But if you're acting as a lawyer and you want to get, for me, right, you don't necessarily have to go for a fashion law course. I mentioned earlier about the various areas of law that you can actually. I did a master's in Babcock, right? And obviously they don't have a specialization, but they have courses on international trade and economic law, and that's where I saw rules of origin, rules of origin, rules of country of origin, things like that. All those principles of most favored nation, it all applies to the fashion industry. So you can actually pick the areas of law and then also get certifications there too.
And you can go general, right?
Yeah, general.
Okay, so I just want to know, right? In registering an IP for the fashion industry, because I think we just mentioned something like the tailors making the dress. Once you make it without illustrating it in a digital form, how do you get to register it first? And secondly, when you illustrate it in a digital form, I had asked the question before, do you register it as a white and black image? Because from the little we know about trademark is, if you're registering, you register as white and black, so that it will be protected in other colors. So do you register it designed and colored, the way you want it in the lace or fabric?
Are you asking for the design itself?
Yes. How do you register?
Like, let's now, you're talking about this
sketch.
dress now. The sketch of this dress.
Yes.
We actually have different opinions.
No, we actually so the truth is, while something is legal, it does not always mean that it makes commercial sense. I think it's a very, very, very big waste of time to register one dress or sketch. What I would say would need registration are markers. If you said all your dresses would have a flower on this place, now all the dresses in your collection all have this flower. If someone, what's your name? Sorry, Judith. If someone sees anybody wearing a dress and that flower on top, they know that this is a Judith's dress. But to say that you want to register every silhouette you make, every dress, you will even be tired. And like I said, it doesn't make any commercial sense. Why? We are in a trend-driven fashion economy. What is fashionable this month will probably have disappeared in 2 months' time. So what do you want to do? You want to just be piling trade. Now, if you feel strongly about it, I would advise that it's something you do for certain kind of things. Let's say gym wear, things that don't have alternating forms every other time. If somebody buys an outfit for the gym, now they may buy 5 pieces, and that's what they will wear every other time they go to the gym. Nobody is going to buy 5 dresses to wear every other day of the week. So those kind of things now, because they have general form, general shape, you can trademark them because it is something that is going to be continuously used over time. And it has to be something that is unique. You cannot register the general form of everything. But if it's something that I know that even if I make 50,000 items, this structure is going to remain the same, then by all means go ahead and do it. Alternatively, register your patterns. This pattern now, register it. This is the best protection you can have, because like I told you, like he was saying, they've not tested the cuts. for certain is that if you have a pattern that is unique to you and it's identifiable for just you, you have way better chances at protecting that than saying this dress, the neck, because the neck is V and it entered under the bust, is my design. Nobody's going to get that one for you.
Yeah. And just to add, like our designers need to start making use of their trademark. Like I always say, what I see is that they have a trademark, but the only thing they use their trademark for is fancy bag or paper bag. But the truth about it is that your trademark can actually be that pattern he's talking about, can be everywhere. And you see that a lot of brands have adopted that method. I think Mayatako, for example, how do you know? Because that dress is actually really basic, but you can see that everybody knows that it's a fake because she used her logo on top of it and everywhere. There's also this dress by House of Maggie. I think Priscilla Ojo wore it at her after wedding. You know, you can see that dress is very artistic and beautiful. Obviously, when you see somebody else create that can be protected, to be honest. But it really depends, and I think a designer knows. But what we see here is that you guys use, a lot of designers use basic fabric and then do basic design and now expect protection.
Okay.
So IP also, like we would say, is a strategy. Like you have to think about IP at the beginning of your creation so that you know that, okay, this thing I'm creating would enjoy IP. But when you're just creating like that and just using plain fabric, you're not doing anything new, basically.
Yeah, let me add to that too, right? Let's be honest with ourselves. Sometimes registration might be tiring. Let's be honest with ourselves, right? And if you have one tailor in your street, that knows how to sew, but you know that's it's going to be a lot of work to be sending out contracts for the tailor to sign. Just don't have too many phone calls with that tailor. Do you understand? You know you can't give a contract, you know you can't register, you know you can't trademark us for all these things. Have conversations that can be traceable. That's what I always tell clients that can't afford to pay lawyers. I'll be like, look, make sure that everything you guys discuss is written. For example, I'll be like, I'll be agreed that everything from the designs to the clothes, as soon as they're done, belongs to me. And you transfer your dress to me. The person will be like, if the person says yes, that's a contract. That's a contract. Pending the time you now start focusing on trademarking or registering marks or whatever you want to do, right? That's one thing you should always put into consideration. Think of other ways. Because I still have a trademark that I've been trying to get for over 3 years.
That's a different
Do you
conversation.
understand? So think of other ways that you can own something without why you wait for the other one. Okay, so patience is not really waiting. Patience is doing something else while you wait for what you're waiting for, in my opinion. Right?
Yeah, okay.
So does that work for a photographer? Like if a photographer is taking my picture.
Now, like I've been saying, since there's something that have not been tested. But if by the time you test it in court, there's a high likelihood that it's going to work in your favor. Because once somebody admits something or someone consents to something, what I feel the court will be focused on is the reasonable man's test, right?
Yeah.
Now, what this person sent, does it look like consent? Once you say yes, obviously you consented to it. You cannot benefit from something and say that no, there's this law that's gonna assist you to escape from that liability. No. That yes to me is enough and it's going to do a whole lot. People have contracts on napkins, people have contracts on serviettes. Just write one or two things. Everything belongs to you. Do you agree? And the guy says yes and signs, and you take a picture. All of you guys take a picture together. You guys are drinking and you're happy. You can't wake up tomorrow and say that. You can't wake up tomorrow and say nonsense. Equity is the vigilant, not the indolent, right? So these are things that you can always try to explore, pending the time you do it, because it's not really easy like that, man. Our trademark registry is closing. Copyright, we know what we're facing. So while that's on the way, do this one.
Yeah. So we're taking the last question. It's already 2 o'clock. Yeah.
Hello everyone. I was really curious about this when I saw fashion law.
I was like, oh, okay, I really want to. But unfortunately, I couldn't get here early enough. But from some of the things I've picked, it's looking like for one to create a niche in fashion law, before one can say, okay, I'm getting this book on fashion law or taking master classes, what you're basically saying is that if you can get some certification in maybe IP or mediation or things like that, and then one can then apply it to the fashion industry. So, but my question is, when it comes to, so there are people that don't have original designs, like retailers that just buy, so there are brands that have gone across board, they do major designs, and then people go to other countries, buy them, bring them to this part of the world, and then there are people that retail. But then in order to sell, they need to perhaps advertise, put their logo on some of the adverts, things like that. So how can such people sort of protect themselves from, because you don't know that something is coming until it comes. When it comes to people then saying, for instance, you should have recognized my work in the scheme of things. So I don't know if my question was communicated.
Okay, right here, we talk about distribution agreements. So generally for big brands or big designers that design to these wholesalers who will now give retailers, there's usually a handing of contracts. What it says sometimes is something along the lines of, I transfer my IP and in this design to so company. Sometimes it comes with a timeline. It might say, oh, for 3 years we would share maybe 30 cents on the dollar for each design sold. There are different ways they can couch it. But the point is that the intent is that once you hand off this design to these people, they will produce it in bulk and it will be sold to other people. So you cannot now come and meet this person and come and be telling them, oh, but this is my design. This, you can't. Because the intent is that that design is going to be mass produced and sold. So that's the distributor agreement that we'll talk about. So now that person does not have any business with you. This person is just like you saying you bought this air conditioner now from a Fairman store down the road. Then you use it to make ads and everything, and then Fairman is messaging you. It doesn't make any sense. You understand? So regardless of whether it's clothing or anything, the bulk has stopped at that wholesaler, that distributor. Whatever arrangement is now between you and that distributor. In fact, if you decide to remove all the labels and put your own label, it still does not do anything. Because per function of that distributor sending or selling those clothes to you, they have handed off whatever you are going to do with it. That's why we have white label garments where you can just go to Turkey and tell them put my tag on all these things. Those things came from someone. So you don't have to be worried, nobody's going to come and bite you.
It's alright then. I think we have come to the end of this session. Thank you so much.